everyone, welcome back to Lex Nomos. Ever wondered why the legislative bodies have never amended the constitution in a manner to give them absolute powers, even though the constitution allows amendments? Today, we are going to discuss one such case that has protected citizens against arbitrary amendments and has also become the cornerstone of the Indian legal system. This case that I am referring to is the Kesavnandabharti case of 1973. Let's go ahead and understand the case and also the facts of this case.
Hello everyone, welcome to Lex Nomos. Today we are going to discuss the most well-known and monumental judgment, Kesavnandabharti vs. State of Kerala 1973. Let's first understand the facts of the case. Kesavnandabharti was the head priest of Ednir Mutt, a religious institution in Kerala. In 1969, the Kerala government enacted the Kerala Land Reforms Act, which imposed restrictions on land ownership, including land held by religious institutions. This law affected the management and property rights of the Ednir Mutt. As a result, in 1970, Kesavnandabharti approached the Supreme Court under Article 32, alleging that his fundamental rights under Article 14, 19, 25, 26 and 31 were violated. At the same time, Parliament had passed several constitutional amendments, particularly the 25th, 24th and 29th amendments, to assert its power to the amend constitution and protect land reform laws from judicial scrutiny. Due to the conflicting earlier judgment, especially Golaknath vs. State of Punjab 1967, the matter was referred to a 13-judge constitutional bench, the largest in the Indian history. Let's understand the primary issues that were placed before the Honorable Supreme Court. First, does Parliament have unlimited power to amend the Constitution under Article 368? And second, can Parliament amend or take away fundamental rights? Third, is there any inherent limitations on Parliament's amending power? The key constitutional provisions involved were Article 368, which provides Parliament the power to amend the Constitution, Article 13, which protects fundamental rights from being violated by laws. Fundamental rights under Part 3 of the Constitution. Previous judgments such as Shankari Prasad and Sajan Singh supported Parliament's amending power, while Golaknath restricted it. This inconsistency necessitated authoritative clarification. After extensive hearings lasting over 68 days, the Supreme Court delivered its judgment on 24th April 1973 by a 7:6 ratio majority. The court held the Parliament does have the power to amend the fundamental rights, thereby overruling the Golaknath. However, this power is not absolute. The court introduced the basic structure doctrine, holding that the Parliament cannot amend the Constitution in a way that destroys or alters its basic structure. Although the court did not define the basic structure exhaustively, it identified essential features such as supremacy of the Constitution, democratic and republic form of government, secularism, federalism, separation of powers, judicial review, rule of the law. In conclusion, the Kesavnandabharti judgment is a cornerstone of Indian constitutional law. It ensured that while Parliament can amend the Constitution to meet the changing societal needs, it cannot destroy its fundamental identity. The basic structure doctrine has since acted as a constitutional safeguard against authoritarianism and has been reaffirmed in later cases such as Indira Gandhi vs. Raj Narayanan, Minerva Mills vs. Union of India. Thus, this case stands as a powerful reminder that the Constitution is supreme and no authority, however powerful, is above its core principles. Thank you.